Judiciary in the dock. This editorial criticizes a growing confrontation within Pakistan's judicial system. It has now come to this: 5 judges versus the President, the Federation, the Judicial Commission, the registrars of the Supreme Court, and the High Courts of Sindh, Punjab, Balochistan, and Islamabad, and 3 of their fellow judges. Has now come to this indicates that the situation has reached a critical, perhaps inevitable point. The phrase 5 judges versus sets up a dramatic conflict between a small group of judges and powerful state institutions, including high courts and executive bodies. The 5 who are serving confirmed judges of the Islamabad High Court have formally challenged the manner in which 3 justices were recently transplanted to the IHC from other high courts, how the IHC's seniority list was subsequently changed, and how far more senior confirmed IHC judges were summarily replaced on important committees by the freshly transferred judges. Serving confirmed judges emphasizes their secure, established positions. Transplanted is a metaphor for moving judges from one court to another, while seniority list and summarily replaced indicate abrupt, non-transparent administrative changes that appear to bypass established norms. The petitioners have called on the Apex Court to exercise its original jurisdiction under Article 184(3) to hear their pleas, as they believe what happened at the IHC is tantamount to dismantling of the salient features of the Constitution, specifically the independence of judiciary, separation of powers, and federalism. They seem to have made a strong case. Apex Court refers to the highest judicial authority, and original jurisdiction means the power to hear a case first. Tantamount to a dismantling uses strong language to claim that the changes effectively destroy essential constitutional principles such as judicial independence, separation of powers, and federalism. It may be recalled that the trouble at the IHC began last year when several judges formally raised the issue of routine meddling by security agencies in court affairs. Trouble refers to ongoing issues. Routine meddling suggests that interference by security agencies had become a regular problem, affecting the integrity of court proceedings. The contents of their complaint, addressed to the then Chief Justice, Qazi Fayez Issa, were corroborated by similar complaints made subsequently by other high courts as well. Corroborated means supported by additional evidence. This indicates that the issue was not isolated but widespread across multiple courts. Unfortunately, the former Chief Justice never had the bandwidth to address these complaints, and the matter was not addressed. Bandwidth is used metaphorically here to mean time or capacity. This implies that even high-ranking officials were unable or unwilling to resolve these issues, leaving them to fester. Now, and especially after the 26th Amendment, a perception has been building up that all judges who are perceived as a threat by the current regime are being systematically sidelined and neutralized by being denied their due promotions and/or deprived of any important administrative responsibilities they may have held. Systematically sidelined and neutralized are metaphors indicating deliberate exclusion and disempowerment. This sentence asserts that judges deemed inconvenient by the regime are being purposely held back from advancement and key roles. The way things have played out in the SC and the IHC in recent months certainly seems to have lent considerable credibility to that perception. SC stands for the Supreme Court. Lent considerable credibility means that recent events have strongly supported the view that judicial independence is being undermined. It has been most disappointing to observe that the petitions against the 26th Amendment have not been taken up with the seriousness and urgency they ought to have attracted from the SC. Taken up means officially considered. This criticizes the Supreme Court for not prioritizing these petitions, thereby neglecting its duty to protect constitutional rights. The judiciary's image as an independent and impartial arbiter has continued to deteriorate as a result. Arbiter means a judge or decision-maker. Deteriorated implies that public confidence in the judiciary's fairness and independence is declining. This petition, if it is taken up, will at least compel various actors to place on the record legal justifications for various actions and decisions which have been publicly perceived as having deprived the judiciary in general and the IHC in particular of their institutional independence, autonomy, and ability to function without fear or favor. Place on the record means to officially document. This implies that a judicial hearing would force transparency regarding actions seen as undermining the judiciary's fundamental principles. It must also be reiterated that it is only proper that petitions pertaining to the independence of the judiciary as an institution are heard by a full court so that there is no complaint regarding conflicts of interest. This stresses that for issues as critical as judicial independence, the entire court should hear the petition to ensure impartiality and avoid any bias. The institutional leadership cannot ignore the growing criticism forever. A final, forceful statement suggesting that the ongoing criticisms of the judiciary's handling of these issues will eventually force a response. Published in Dawn, February 22, 2025.